It is such a pleasure to be here. I've been having fabulous conversations with some of your folks and look forward to more later today, including with the fellows. This topic, I've been diving deep into this topic, and it may seem really like a snooze, but I hope you will find it is actually pretty darn interesting and also kind of crazy as we get further into this. I've been on an IRB since sometime before Moses or Methuselah. And one day we were, just sitting in an IRB meeting. And so somebody mentioned something about the LAR, legally authorized representative, to speak on behalf of somebody who has not got the capacity to make decisions about whether to enter the research. And it was the director of the IRB, and she was mistaken about Tennessee law regarding how to choose the right person to make the decision on behalf of that person. And so I started digging in, and the deeper I dug, the crazier it got, as you will see. Okay, this is going to be very interactive. So, open your potato chip bags now, okay? Okay, here we go. No disclosures, don't I wish. This is a work in progress, and I note that is a wine bottle, rest assured. So this is Betsy. Betsy is a lovely lady. She is 75, generally actually very healthy. She loves gardening and loves watching HGTV, the part at the end about the reveal, where they show the before and after. And I see recognition in some faces and blank in others. Now I know what you watch. She quite possibly has mild, maybe even moderate dementia. It's never been diagnosed. Her only recent medical encounters, hip replacement about 7 years ago, cataract surgery 2 years ago. I know what that is. Not a biggie. If you're heading there, pony up if you can for the lenses that will give you both distance and reading. I have free reading glasses to give away because I don't need them. Not anymore. Okay, Betsy's BFF is 57-year-old Minnie May, who lives right next door. Everybody needs a BFF Minnie May. Minnie drives Betsy for groceries, church, the book club. Minnie kind of knows that Betsy's kind of been slipping a little bit. So Minnie unplugged the stove. You want to make sure somebody doesn't burn the house down, you unplug the stove. Teach her how to use the microwave, okay, and arrange for Meals on Wheels. So good deal. Frank, Betsy's son, lives a couple hundred miles away, occasionally sends a Mother's Day card. Frank did make sure the bills get paid. He arranged for a joint checking account. He is the person who receives her Social Security payments, okay? And he makes damn sure the bills are paid. He does not need to lose the house to tax foreclosure or to find his mother dead and him blamed because she froze to death because the utilities didn't get paid, okay? So Frank takes care of that stuff. All right. Nevertheless, Betsy is sad that Frank doesn't pay more attention. She sees an ad on TV for research for a new drug for depression. She says, I think I would like to go and maybe sign up for this new depression drug. I think I'm depressed. So she goes there, Minnie takes her, and the nurse coordinator, she's a pretty good candidate for this study, okay? And like so many drug trials, they are under substantial pressure to recruit a designated number of people under deadline. Drug trials are very expensive. High pressure, that patent is ticking. The clock is ticking, okay? No matter how much of it gets wasted doing your clinical trials, it will expire in that typically 17 years, okay? On the other hand, the research coordinator senses Betsy might be having a few challenges with memory and cognitive processing. So 2 questions, and I want y'all's thoughts. What should this coordinator do about her questions about Betsy's capacity for decision-making? And in the end, if it turns out that Betsy lacks capacity, who would be the LAR? So first, what should the nurse coordinator do concretely about her suspicions that Betsy may have some dementia? What should she do? To what?
Does he figure out if she actually does that?
Okay, so you think the nurse coordinator should undertake the capacity evaluation and make the determination. So how many people think that the investigator or the research coordinator, whoever, should decide whether Betsy has capacity? Okay, a number of you. How many think that no, the research person should not make the final determination? You may be thinking the initial threshold to raise questions, but how many think that somebody who's not in the research ought to make? I saw bunches of hands both times, maybe some more hands this time. Okay, if in the end, however it's determined, Betsy, lacks the ability, who's the LAR, legally authorized representative to say yes or no, Betsy goes into the drug trial? Who should it be? Shout it out. Her son. Anybody want to vote for Minnie Mae? Well, that's a thought. If she's demented, depends on how far along. Yeah. Okay. So we have some thoughts on this. Okay. So suppose now this takes place in Colorado. Who might be the legally authorized representative in Colorado? I'd have to, damn good answer. Thank you. Okay. I'm going to foreshadow something. If you're in Colorado, for ordinary treatment, the way you find a surrogate where somebody cannot make his or her own medical decisions is you reach out to the friends and family and ask them to bring in more friends and family and ask them to choose a surrogate. What? Okay, that's true. That's true. That's how you do it in Colorado and Hawaii and Montana. And I don't know how many other states, but I mean, I've been doing a deep dive. I will not say I've done all 50 states plus DC. I've got upwards of 40, very deep dive, as you'll see. Little bit of history from the late 90s, early 00s. Back in the day, because of various adverse events like death, okay, Ellen Roche, who was at Hopkins in a trial, she was a healthy volunteer in a trial. She died. She comes up dead. And there were some other problems, Duke, Hopkins, various others. The feds just shut down all human subjects research. And by the way, in 1998, the DHHS, Department of Health and Human Services, the Office of Inspector General wrote a big report saying IRBs are a mess. And this crops up after that, okay? They're reviewing way too many protocols, not looking at them seriously enough. Like at the time of this, Hopkins IRB, the only IRB they had, was meeting every other week to review hundreds of protocols, okay? That was the extent. Duke was a mess as well. The next thing that happened, a flurry of lawsuits. These were triggered by Jesse Gelsinger's death in a gene transfer study in 1999. He had ornithine transcarbamylase deficiency. And I'm not a doctor, and I can pronounce that. Okay, I said it. Ornithine transcarbamylase deficiency. Do I get an MD? Thank you. Okay, okay. And maybe a few other things that I have to do first. Okay, anyway, he had a very mild version of the disease. It was a gene transfer study. He died of fulminant liver failure. This is not a good thing. Okay, so big national scandal suit, you name it. Okay, the IRB was not named as a defendant in that one, but in the ones that have a check mark, as this got rolling, the lawyer Alan Milstein, who was based in both Pennsylvania and New Jersey, ended up filing lots of these suits, okay? In all of these that have a check mark, the IRB, either all of the individual members of the IRB got named as defendants, sometimes the head of the IRB, sometimes the IRB as a body got named. As you can see, there were a whole lot of lawsuits, and IRBs got nervous, okay? All right, how's our malpractice coverage doing here? Okay, anybody here ever been on an IRB? Okay, so I see some hands up. Have you been near or participated in clinical research? Okay, bunches of hands going up. Some of you have had to bring protocols to the IRB or, okay. Oh yeah, I see some serious nods of affirmation here. Okay, so this is your life. Okay. One question back then, obviously risk, benefit, balances, all that was relevant, but one question concerned capacity and surrogate consent, those two things that we're going to look at. Because the common rule at that time just said, well, you pick the LAR that's authorized under applicable law to consent for research. Well, guess what? Most states didn't have anything governing research, and they still don't. Very few states have any statute specifically governing research and capacity assessments and LARs. Okay, it's just nothing there. So what we have, they got with OHRP, Office of Human Research Protections. All right. And they came riding, galloping into the rescue. Okay, sort of, pretty much, as much as they could. First thing, it's determined by the laws of the jurisdiction in which the research is conducted. You cannot borrow somebody else's law, okay? And what you can do, most states have no law specifically addressing consenting research, so it's okay. You go for the law that addresses medical treatment. And if you got, whoever is the suitable surrogate for medical treatment, boom, you got it for an LAR for research. Okay, cool, up to a point, okay? And so it's, what you're asking for is a reasonable basis in that jurisdiction's law. Well, let's take a look at a few jurisdictions. What the OHRP did, or what the common rule then did, they added the definition of LAR, an individual recognized by institutional policy, which usually means the IRB, okay, as providing consent in the non-research context. That means ordinary treatment. So now the very definition of an LAR includes, it's okay, if you don't have a real research statute, go for your regular, ordinary medical care, non-research. Okay, good to go for a moment. Okay, this is the upshot. Base it on ordinary treatment, and you have to look for the laws of that particular state. So let's get into the wilderness of state statutes. As they taught us in law school, read the rules. It is astonishing what you will find there. Oh, yes, my. Okay, the statutes are a mess, just a royal mess, okay? Now, every state has at least something that you've got from the get-go. Every state lets a court make an adjudication that someone lacks capacity and to then identify a conservator. You have to look at the documents, though. We had an ethics consult at one of the major hospital systems in Memphis, and the problem was, all right, Memphis, I was told before I moved to Memphis, Tennessee, that Memphis is not in Tennessee. Memphis is the capital of North Mississippi. It kind of is, because the legislature of Tennessee doesn't like us or know that we exist, but that's another topic. Anyway, a guy who was from Mississippi and was in a Memphis hospital who had a conservator, a guardian. States use the term, it'll select, whichever they choose. So I'll use the term conservator. But the conservator is in Mississippi, and then he's in Memphis. Does the conservator get to say, oh, what happens in a Memphis hospital? I said, can I look at the document? Because the conservator was really hard to reach. I mean, he was just non-responsive. I said, can I see the document? It was not a conservator of the person. It was a conservator of the estate. Completely inapplicable, okay? Read the rules, okay? Amazing what you can find there. Okay, so every state allows a court-appointed conservator, and it can take an enormous amount of time. Typically, somebody has to pay a guardian ad litem to advise the court on the interests of the person who might be the conservatee, yada, yada, yada. It's a very lengthy, complex process. The other thing is, basically every state has an option for filling out an advance directive and appointing someone as your agent, or maybe several people in sequence who can make decisions for you as a durable power of attorney, or also called agent for healthcare decision making. And by the way, Somebody just shows up and says, hi, I'm the DPOA, I'm the POA. That is not a POA. You have to have the right piece of paper with the right kinds of ink. Every state that I've looked at requires that either it be notarized or two witnesses, at least one of whom is not related and does not stand to inherit. If you do not have the piece of paper, you have no POA, okay? And it's amazing how easy it is to get all screwed up about that. Okay, so those two, yep, you got it right there. But other than that, then you look at surrogacy provisions, and I'm using that term in a generic way, for capacity and surrogacy selection. So let's look at state variations on who should figure out whether a person has capacity. A lot of states, including Illinois, go for the attending physician, also known as primary or designated or treating. Tennessee uses the word designated. It's the same thing. The definition matches in every case. The one who has primary care. And you might have more than one attending, and that's okay. It's whoever steps up for this decision at the moment. Okay. Some states require the attending plus somebody else. So Oklahoma, the attending plus another physician who has actually examined the patient. Michigan, either the attending and either a licensed psychologist or another licensed physician. One guy isn't enough. That matters, okay? Some other states, it can be attending or another clinician caring for the patient. So you'll add an advanced practice nurse practitioner, registered nurse, or a PA, okay? And depending on scope of practice laws in that state, the registered nurse advanced practice may have truly thorough attending authority, even if not under, quote, supervision of a physician. Some physician's assistants have that as well. And then some more jurisdictions, a physician, but not necessarily the attending, okay? A little bit more leeway. So Missouri, 2 licensed physicians who examine the patient. Montana, healthcare provider, experienced in this kind of assessment. DC, 2 professionals licensed in District of Columbia, qualified, and one of them has to be a doctor. The other one has to be either a psychiatrist or a licensed psychologist. It matters. And I really want to emphasize that when you say somebody is no longer able to make his or her own decisions, that person loses rights. You lose important rights to stand up for yourself. Yes, Dr. Angela.
In any of the statutes, does it specify that there are 2 attending physicians as opposed to an attending and their resident or attending and their fellow?
I have not seen that. I cannot say, yeah, I mean, I can only go with the statutes I've seen. But licensed physicians is, okay, that's part of the definition. And so to what extent, a July intern probably are they licensed in your state yet? So yeah, now we get into the weeds, big weeds. Okay, good question. All right. So, all right, IRB's challenges. 3 questions, and I'm not going to go into a lot of detail. These things are actually pretty resolvable. Can the investigator look into the electronic medical record to find out who the attending is? Second question, what if the investigator is also the attending? This happens a lot in surgery trials, okay? Like trauma surgery, whatever it might be, okay? 3, if the state does not actually require an attending, which some of them don't, how do you define the appropriate process if you're in the IRB? Because you're looking for IRB policies to define this kind of stuff. So let's look at that first one. Read the rules, okay? You can, just because you're a nice person and you want to do some really helpful science does not mean you get to snoop into my medical record. But there's an answer. HIPAA has very specific processes, uses disclosures for research purposes. IRB, and this is not rocket science. The IRB needs to enact a policy whereby they can grant waivers according to various restrictions in this part of the HIPAA statute. This is not rocket science. You can do this, okay? And so the investigator needs to apply to the IRB to get that permission before you go snooping into my darn medical records to find out who's my attending, if I have one. So go for it. You can do this. So what about the second one? What if the investigator is also the attending physician? Answer, most states there's no real guidance. Ethically, I got a problem. There's a big fat conflict of interest. Remember, this research is under pressure and they get bounties per head for every person they enroll. Big fat conflict of interest, okay? And even if I'm not going to get lots of cash, the investigator is intellectually invested, professionally invested, sometimes certainly emotionally invested, and we want that. That's a good thing. I don't want investigators who think their research is a dumb idea, okay? That would not impress me. Okay, so I like what New Jersey has. They have an actual research-specific statute. Determination about capacity shall be made by an attending with no connection to the proposed research. So if you got nothing, that would be a reasonable thing to fill in the blanks with. You know, I would love to get some more work with the OHRP to say, hi, would you please bless this? You know, and make a nice big broad blessing. Okay, let's look at question 3. If they don't require an attending, now what? Okay. Or if the patient doesn't have an attending. Does Betsy have an attending? 7 years ago, hip surgery. 2 years ago, cataract. I'm telling you right now, probably neither of them gave a crap about whether she had capacity. The cataract surgery is really obvious. If she's getting really blind, it's very harmless. I mean, they're not going to dive into that. And 7 years ago, she was probably fine from a capacity point of view. And she hadn't been seeing any doctors. So here's what is another approach that you can do. Get with the OHRP. This is part of advocacy, okay? To bless the idea of having a cadre of physicians who are qualified, who would be willing to step up to do this kind of evaluation and serve as an attending, quote unquote, for this person to make this determination. Plus, whoever you need, if you're in DC, you got to have in your cadre licensed psychologists and or psychiatrists, okay? It's manageable. And something else I want to highlight, investigators should build money into grants for paying for these. You shouldn't expect doctors to take their time to do this just for the fun of it, okay? They deserve to be compensated. And that needs to be part of the grant. Okay, I'm very practical. I want to know how exactly am I going to get from point A to point B. Yep. All right, now, oh yeah. Now we get into surrogacy. We thought that, I mean, capacity determinations are manageable. Yeah, okay. Surrogacy determinations. Who's going to speak for Betsy? There are 4 major approaches. One, very familiar, next of kin, lockstep order in hierarchy. I will say there's a lot of variation in what do you do if the adult children, if there's a spouse, okay, there's usually just one of them in this country, okay? If you watch Sister Wives, you know, never mind that. And no, I don't watch it, but I've heard of it, okay? Okay, so some of the states say, well, you should urge them to come to consensus. How many think that's real? Realistic to expect fighting siblings, you know, the adult children, oh, well, we'll come to a consensus. Yeah, right. Others go for a majority vote. Okay, other states say go directly to court. Do not pass go, do not collect $100. Court will figure out who's the surrogate. Oh, that's complicated. Okay, but that's the law in those states. Next, now this is Tennessee. And I love Arkansas, California. I love this statute for ordinary treatment. Instead of being stuck lockstep with a spouse who may have been living somewhere in South Carolina for the last 10 years, they hate each other and do not have the money to divorce. You are not stuck with an estranged spouse or an estranged father who hates the guy and, you know, has not have a civil word for the last 20 years. You find someone who has shown caring and concern, who knows the patient and her values and is willing to step up. How lovely. Okay. More complicated when it comes to research, however. Okay. A third approach The attending, and this is one I told you about, contacts all the friends and family, asks them to reach out to further friends and family. Tell me who should be the surrogate. All y'all carry your vote, okay? I don't know if they even do that for treatment, okay? They probably ask whatever friends and family are right there, but for actually, combing the woods to find more friends and family, yeah, I doubt that happens very much. Okay. Fourth approach, and this is one that some of you will find quite surprising. A number of states have absolutely nothing other than a durable power of attorney or court-ordered conservator. Nothing for surrogacy, for ordinary treatment for a demented person who just needs regular medical care and maybe a little surgical intervention or something, okay? Zero. There are a few states where actually, like Ohio, for example, yeah, they have a next of kin list, but it only applies if the patient is terminally ill or permanently unconscious. So family can pull the plug, nothing else. It's a blank, it's a vacuum, okay? And then it's for ordinary treatment, okay? Oh dear. Now, let's go back to Betsy. Time to have some fun. Remember, she's healthy, loves gardening, probably some dementia, not much medical care. BFF is Minnie Mae. Frank, not too involved, but he takes care of certain necessities. And, excuse me, I should say Betsy presents to be evaluated for the study of the depression bug. Suppose she lives in Illinois. How do you determine capacity if Betsy lives in Illinois? Attending physician. Score! Okay, that is Illinois law. How do you get there? How do you find out who is the attending? Get your HIPAA waiver, yes. You don't go snooping in somebody's records, okay? They will track you. Okay, so now it's a little more complicated though. I mean, if you do get, oops, sorry, who's the attending? Her also? We saw her 2 years ago? Just, hi, I mean, people with dementia, as many of you are aware, can cover for a long time, okay? We had a family member who, there is a reality here, and it's a sort of a sad reality, but people who began, at least with more education and affluence, tend to be able to cover longer because A, they get an assumption that they are competent, and B, they also have certain social grace fluid, remarks that, oh, isn't that nice, kind of, so they'll sound like they're with it for longer than they actually are. So, I doubt the off though. What do? There is no attending. You have to have the attending. It has to be the treating attending. What are you going to do? Well, work with the IRB. And again, we need some help from OHRP, Office of Human Research Protection, to give us some more options where there is no attending. Just like 20 years ago or more, when there is no state-based research statute, they said, okay, you can go with treatment. They filled in the blank, which was really a good thing. And they need to do it some more. Advocacy says, let's work with OHRP and the IRB to figure out what will be a reasonable basis for addressing this deficiency. Okay, whoop. Okay, so how to select an LAR in Illinois? Who's the legally authorized representative if you're in Illinois? Oh, you know this. I promise you know the correct answer. It's Frank, yeah, it's her son. This is the order of go. And by the way, notice here, not many states distinguish these, as I just did a moment ago. Guardian of the person. Now, if there is no durable power of attorney, then you go for court, spouse, adult, child, parent, sibling, boom, boom, boom. Okay? So far, so good. And yeah, technically it has to be Frank. Are you happy with Frank as the LAR? Raise your hand if you're thrilled to have Frank speaking on Betsy's behalf. I don't see any hands. How many, raise your hand if you'd kind of rather see Minnie May. Oh, a lot of hands. So who raised your hand for Minnie May? Okay, Dr. Angelos, why would you rather see Minnie May than Frank? How do you know that? Yeah. I mean, the heck of it is that in an ordinary treatment, let alone research visit situation, all you know is what somebody says to you that our relationship is or that their relationship is. I would bet many people in this room have seen various family members for an incapacitated patient saying, oh, yeah, that person, ugh, they don't get along. They hate mom. Mom is in the bed. Oh, he hates mom. Mom hates him. Don't, ugh, he should not be in these conversations. I think you should shut him out altogether. I mean, we get this. All you know is what someone says to you. And that makes it hard. Now, if you're able to get into the real medical records, you might, and if there is a primary care attending who did not spend all the EMR time checking boxes and actually put in a few narrative notes about relationships, wow, that would be very helpful. But basically, in Illinois, you're pretty well stuck with Frank because you've got Frank, okay? So let's see. Now, suppose Betsy lives in Tennessee. In Tennessee, capacity issue is the same. Tennessee requires the attending, right? Same kind of deal. HIPAA waiver, ortho, probably not going to get any information about capacity from either of those sets of medical notes. And again, I really like the idea of a cadre of independent physicians who are going to be properly compensated for their time and effort. But that is not a thing, all right? That's going to require some advocacy. So, okay, now, again, in Tennessee, supervising healthcare provider selects someone who has shown caring and concern. Who should do the selecting is the first question. Should the research investigator or the nurse coordinator select Betsy versus Minnie May? What do you think? I call on people. I am ruthless. Okay, who should? Yeah, she doesn't really have one. I mean, there is no short, thank you. There is no short answer, okay? This is complicated. And this is why, my head gets spinning when and this is the simple stuff, okay? This is the easy stuff, all right? I will say what our IRB did was the Tennessee law says that the attending may consider next of kin in the following order. So you can say, well, that provides a reasonable basis for the IRB policy for my institution is next of kin, which is much clearer. Now, I'm not totally thrilled that Frank is it, but maybe Frank cares about her. And maybe there's a reason that Frank has stayed away all these years. And that then, maybe Betsy was a nasty, irascible old woman from the day that Frank was born. I don't know. We don't know their relationship. So, okay. Now she's in Colorado. Oh my goodness. Capacity, we've already talked about that. Colorado is this wonderful thing where you just assemble masses of people and get them to vote for one person to be the surrogate. What do you think? How will you go about selecting LAR for Betsy? Now, if you get access to the EMR and somebody as attending has already done this, thank heaven, go right off into the sunset with immense gratitude, okay, that you don't have to fool with that. I don't know what the heck you do. I mean, it's impossibly complex for the research setting, given that the investigator is not the one who should be rustling all this up and getting this. Okay, it's a big gap. I feel like that a lot, especially the messy hair on top of everything else. That's when you bring the wine bottle for work in progress, okay? Now we're in Kansas. Oh, Toto, we're in Kansas, thank heaven. Okay. Kansas, for treatment setting, Kansas has nothing anything other than a durable power of attorney or a court-chosen conservator. What are you going to do? Oh, and by the way, not merely do they have nothing, but about 15-ish years ago, they actually had a commission, a big old commission, studying, well, we need to fix this gap, okay? And they came up with a very familiar next of kin approach to surrogacy because they had nothing for treatment of ordinary medical care. And the Kansas legislature said, hell no. So when you have concrete evidence that the legislature not only has not adopted one, they have emphatically said no, you can't just make stuff up, okay? You can't, well, we'll just use next of kin. No, you cannot use some other state's law. You cannot just make up stuff. You have to go with the law of the jurisdiction where you are, which is absolutely nothing. But wait, there's more. Kansas has a research-specific statute. Yeah, glump, glump, you know, riding to the rescue. And here's what they do. There are various requirements. And for surrogacy, it's either a DPOA, first choice, guardian, next choice, and then spouse. And then it's only those four that are listed. But any adult relative, so you can have a grandparent, an adult sibling, you know, whoever you can grab. Okay. So, all right, now suppose we live that Betsy is in Massachusetts. Absolutely. It's a black hole in space. No research statute, no nothing, nothing, nothing. And this is not the only state where that is true. Go to Minnesota, just the Northwest. Yeah, I grew up there. I got the heck south. Okay. Because I like being warm, just saying. Okay. Now I'm curious. I tried to get IRB policy for Harvard Medical Center online. All I could find was this, very official looking. Investigators shall not use individuals unless they're satisfied that they or others legally responsible consent freely and with understanding. Isn't that nice? They should be satisfied. Well, I'm so glad. Is this acceptable? And I asked a friend who is at Harvard, can you know, this may not have been a real Harvard Medical Center IRB policy. So I said, you're at Harvard, you're one of those important people. Can you noodle around and find? So he asked a colleague, and the colleague said, well, though I'm not an expert, my understanding is that most local institutions here in Massachusetts consider the surrogate healthcare provider as a surrogate decision maker, excuse me, appointed guardian or otherwise. Well, they consider the surrogate to have legal standing for research just as for non-research. So if you fabricate something for non-research, then you rely on that fabrication to fabricate a research policy, right? Is this okay? Oh, hell no. Okay. Oops, I said a bad word. Okay. Recall, you have to base it on, if you have no research-specific statute, you base it on statutes governing ordinary treatment. It has to be the law of that jurisdiction, not some other state. This is a big gap. It's the black hole in space. So legally, and this is going to be my argument, legally in the state of Massachusetts and several other states, Ohio, as I mentioned, is one of the ones where, yeah, we got next of kin, but only if you're dying or permanently unconscious. That's the only time we have next of kin. Otherwise, nothing. The only legal research is people who have a conservator or a durable power of attorney. And I will add, in my deep dive into statutes, there are plenty of places where conservators have limits on what they can consent to on experimentation, experimental treatment, okay? So you got to look out for that as well. Isn't it fun being a lawyer? Valerie, give it to me, girl. You gotta be a rules wonk to get into this stuff. Okay. What a mess. It's just a mess. And, you know, the further I dig into these statutes, I'm wondering which level of inferno I'm in now, okay? Because as you know, every time you read a policy, a statute, a medical journal article, you see stuff you never noticed before. I mean, it just is, okay? What does advocacy look like? Oh my. Let's make sure, oh, we're in decent shape, just the right shape. Step one, this matters. This is not trivial. This is not just, oh, the stupid lawyers just didn't do their job. Oh, legislators didn't do their job. But anyway, some of the worst abuses in human research have circled around people who could not speak for themselves. This matters. That's an advocacy step one. And for treatment, if there's a little fudginess, the goal is the focus, the point of treatment is to benefit the patient. The point of research is not to benefit the patient. Patient might benefit, and wouldn't that be lovely? And some research benefits a lot of patients, especially future ones. It is never the focus of research to benefit any individual person. And I published an article years ago that the clinical investigator is not a fiduciary. A doctor is. Sometimes, in some states, literally, legally fiduciary, in other states, informally so. But investigators are never fiduciaries because their number one obligation is to the science, not the individual. We have in research what I call side constraints on what investigators can do with respect to human subjects. They're very strong side constraints, but they are not a fiduciary type focus. Okay, step two, be willing to be the skunk at the garden party, okay? Sometimes it helps to have other skunks with you. And they're so cute, okay? And step four, make the right thing easy and the wrong thing difficult. And this comes from, all right, I used to be, before I did road, driving schools on racetracks, for about 20 years, I was a card-carrying member of the horsey set, fox hunting in Virginia. Okay, now, I had the wonderful privilege of sitting in on a couple of clinics from a true horse whisperer, Ray Hunt, okay? And people would bring horses from far and wide who were incorrigible. Stop and think what it takes to get this being with a mind and thoughts and fears to go into a black box from which there is no apparent exit. Think about what you've got to do to get to this horse's mind. And people would bring horses who were absolutely impossible, whether about loading, about bucking off the rider, whatever. He would work with them for a remarkably brief time. And the horse would calm down and say, okay, I can try it. Okay. And what he would do is, with various tools, and I won't go into the details, but he would make the right thing easy. So for loading a trailer into a trailer, I'll give you one example. He had a flag, like a noisy plastic flag on the end of a long pole. You kind of wave it. You stand behind the horse, kind of wave it. It's annoying. See it out of peripheral vision and hear it. It's something the horse would want to get away from. Wave it on the other side. Wave it. And the moment the horse took one small step in the right direction, the waving stopped. Make the right thing easy. And then if the horse didn't make additional, then the waving would start again. Okay? That was one small example of what he would do. Pretty cool, pretty cool. So what does advocacy look like in concrete? Here's some more ideas. Do we just stop doing research on anyone who lacks capacity? No, it's not necessary and it's a bad idea. Because a lot of people, including children, if no one is a research subject, everyone is an experimental subject, okay? Research well done is a good thing, whether for incapacitated adults, kids, whoever, but you gotta be careful. Next thing, learn your own jurisdiction's laws. Obviously, many of you have paid attention to Illinois. Is the reaction many doctors get? It's the very word, law. Okay. Fix goofed up policies. If your IRB does not yet have a HIPAA waiver for letting researchers get into, oh, I see a lot of identification with law. Okay. I get you. I hear you. Yeah. I used to couldn't spell lawyer, and now I are one. Okay. And fixing problems, this is an example from one IRB. It says point blank, investigators are responsible for assessing the subject's capacity to consent. Ew. Oops. The state says has to be made by the attending. You got to fix that. Okay, be the skunk, get some other skunks, but go to the garden party and fix that. Okay, get the HIPAA waiver and make sure. See, if you're a grant reviewer or an IRB reviewer, oh, you've got power. Okay, I've done in the last couple of years a number of panels reviewing grant applications, research grant for the Department of Defense. I am their worst nightmare. Okay, so much fun. A big part of my job is to educate, okay? And those who deserve a big ding will get a big ding. Others will just sort of get educated. So one study that was going to be exclusively in the District of Columbia, okay, I made sure they understood they have to have 2 people assessed for capacity, one of whom must be a licensed physician, the other has to be a psychiatrist or licensed psychologist. You got to do that, so that they'll know what to do with the next time around if they don't get the application this time or the grant award. Okay? If you're reviewing grants, oh yeah, you got a nice skunk opportunity. Here's another thing, and I love this, stolen from New Jersey, which does have a research-specific statute. Determination of capacity made by an attending with no connection to the proposed research. That is who should make capacity determinations. Get yourself that cadre of independent physicians, figure out a proper payment scale. If you have enough of them, scheduling would not have to be that difficult, okay? LARs. In next of kin states, again, you gotta figure out, first of all, make sure you have the right hierarchy. Some of them don't include aunts and uncles, most of them don't, grandparents. Find out what's the right hierarchy. Or for addressing disagreements, go with your state. Majority, go to court. But here, I like this one. If there's disagreement, don't enroll the person. And that comes from a statute. The Virginia, if 2 or more people, say adult children, at the same decision-making priority, if they disagree, don't enroll the person. That's in the Virginia statute. I like that. That's very simple. No need to spend a lot of time fighting. If they have legitimate disagreements, who's the next applicant? And again, you're going to get pushback. If people are under a big fat deadline and per head payment to enroll people in a drug trial or whatever kind of research, you're going to get pushback. But if the IRB policy is what it is and your IRB has, the proper weight, then good for them. All right. States requiring outreach to family and friends. I don't know what you do there. But again, you need to create something reasonable. And again, we got another black hole here. In states that have nothing for treatment, there is no legally authorized representative. Face it, get it in black and white, recognize it. Here are a few thoughts. Back in the early 2000s, the OHRP helped. I think I've mentioned that before, okay? They might help now if IRBs come to them and say, we have a problem, here's how you can help. Never just say, oh, we got a problem, solve it for us. No, 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 do not leave that to chance. Here's how we ask you to solve it. Hand them something concrete with good reasons for it. Okay, here's another one. In terms of advocacy, in legislatures and OHRP, these powerhouse institutions, if they come and say, look, we need help, here's the help we need, and major pharma, and you can lobby OHRP, you can also obviously lobby legislatures. That can take a long time. As persons who have spent time in New York know, okay? It took years to get New York off of that blank slate that it had. That said, a motivator can certainly be scandal. This is from a month ago, less than a month ago. This article is updated. But drug makers did not tell volunteers in the Alzheimer's trials. And by the way, if you've got Alzheimer's, it isn't just the volunteer who wasn't told, it was the LAR who also was not told, okay, about certain genetic propensities to Alzheimer's. To my knowledge, the scandal here did not concretely involve not choosing the right LAR, that kind of, okay, it could. It could. If we dug into this, I'll bet you a number of those LARs were not chosen according to state law. Okay? It's a possibility. So I looked at y'all's policy. Y'all doing good. All right. One tweak, I would suggest you need the HIPAA thing. You need the HIPAA waiver to get access to the EMRs to learn who's the attending. Boom. How are we doing?